Good morning, everyone, and welcome to the Australian Human Rights Commission's webinar on civil society, artificial intelligence and human rights. My name is Edward Santo, and I'm the Australian Human Rights Commissioner, and it is a great pleasure to welcome you all this morning. I am currently coming to you from the land of the Gadigal people of the Eora Nation, and I pay tribute to the elders past, present and emerging of this land. I also acknowledge that we have people dialing in from all over Australia and indeed from other countries as well. And so I also acknowledge traditional owners of the land that all of you are on as well. In a few moments, I'm going to run through some of the the agenda and some of the admin for this morning. But I first want to introduce my two co-panel members this morning. The first is Professor Kate Crawford. Kate is best known as a leading international scholar on the social implications of artificial intelligence. But she is a true Renaissance person with another life as a composer and musician. So keen observers will recognize her as one of the two members of BIFTEC, whose song Machines Work you have just been listening to as we started this morning's webinar. But by day, Professor Crawford wears many hats, including as a research professor at USC Annenberg and senior principal researcher at Microsoft Research in New York. Her most recent book, Atlas of AI, is a must-read for the discerning civil society advocate. The other person who will be joining us on the webinar today is Hugh de Kretser. Hugh is the Executive Director of the Human Rights Law Centre, and he might or might not forgive me for describing him as a twinkling star in Australia's human rights firmament. He has been a leading human rights advocate for many years here in Australia and internationally, and for nearly a decade, he has been Executive Director of the Human Rights Law Centre. He has a particular expertise in human rights and technology. So in about 15 minutes, you'll hear from Kate and Hugh. But first, I'm going to talk to you a bit about our Human Rights and Technology report, which was tabled in Parliament just a couple of weeks ago. But as before I get too much ahead of steam, I want to mention a few kind of technical issues. The first is that this webinar is being recorded, and we plan to upload the recording onto the Human Rights Commission's YouTube channel. So particularly if you are having technological difficulties today, I recognise the irony if that is the case. Your best bet is to log out and come back on, but failing that, as I say, hopefully you'll be able to review the webinar later by YouTube. Secondly, if you wish to participate, you can do so by asking questions using the Q&A function on Zoom, and you can particularly focus on that Q&A function because we are not using the chat function. So if you want to ask a question or if you want to kind of vote up particular questions, then I urge you to use the Q&A. I want to draw your attention to the fact that we have a number of accessibility functions. So you will be familiar with Auslan, and so there will be two Auslan interpreters working over the course of this webinar, Chelsea and Kat. So you can use Auslan through them, and we also have captioning that is occurring on a live basis. And finally, I note that we will have an evaluation survey that we'll be sending out after today's session. So as I mentioned a moment ago, I'm going to start by talking you through some of the key elements of our Human Rights and Technology final report, which has been very recently tabled in Parliament. It's been a labour of love and certainly a labour of work in that we started this project a bit over 3 years ago, and we have focused on ensuring that we've been able to consult with as many people in the community as have wanted to have their voices heard, with a particular focus on civil society. And throughout that process, what we've tried to do is two things. One, get a clear picture of what the human rights implications of artificial intelligence are. And two, make sure that in this changing world, there is no question that we're living in truly revolutionary times where technology is radically upending the way in which we live our lives. That in that changing world, our human rights are effectively upheld. And that's been the central focus of our project and is the central focus of our report and the recommendations contained in that report. So really, when we talk about human rights and the rise of artificial intelligence, I'm often struck by sort of competing visions. It almost feels like a fever dream of competing visions. On the one hand, we have the kind of utopian vision that AI will completely improve the way in which we live our lives and will make our world more inclusive. And similarly, there's a dystopian vision where AI will lead to new forms of unfairness, discrimination, and violations of human rights. And in a sense, what our report shows is that both of those visions exist simultaneously for good reason. In other words, the promise of AI is real. AI genuinely can make our world better, can improve decision-making by making it more data-driven. But the opposite is also true, that AI can create new forms of unfairness. So a central focus of our work has basically been to avoid the AI dystopia. Just last week, on Friday, we had the federal court formally approve the settlement in what has become known as the Robodebt scheme, where, as I'm sure all of you are aware, the Australian government used an automated system to try and recover claimed debts from people who receive welfare payments. What we know is that there were very significant problems with that scheme, that the automated process led to high rates of error, and those errors could cause terrible suffering for people who were affected. And indeed, the process to review those errors was made much more difficult than it needed to be. So we have to learn from that history. We say that the lesson is not that we need to throw out all of our computers and rely solely on the abacus to make decisions. No, what we say is we can use technology and we can specifically use artificial intelligence to improve decision making, but we must do so in the right way. So that's going to be kind of the focus of the remaining sort of 10 minutes of opening remarks that I want to make. One of the interesting things that we saw throughout our consultation process was that the Australian public had quite a strong instinctive sense about the importance of accountability when it comes to the use of AI. So I've just put up a slide which shows that a very strong majority of people, between sort of 85 and 88% of people who were polled in opinion polling commissioned by us, said that they want better accountability mechanisms whenever the government uses automation to make decisions. So automation can be used in almost any category of decision making. And as I referred to a moment ago, it was certainly used in what became known as Robodebt. And so in particular, what we saw was that a very strong majority of people wanted to have a clear right to appeal automated decisions. They didn't want those decisions to be opaque. In other words, they wanted to be given reasons for automated decisions by government. And they also wanted to know that it was an automated decision. They wanted to know essentially whether it's a human decision, whether it's an automated decision or some kind of combination of both. And I think that clear message about accountability was something that we heard universally across all of our consultation processes. And really at the heart of our report are three things. The first is that the use of AI should be more accountable. The second is that the use of AI in decision-making should always be accurate. And the third is that it should always be fair. And so I'm going to move now to look a bit more at those ideas of accuracy and fairness when it comes to the use of AI in decision-making. So the $3 term when it comes to unfairness in the use of our AI is algorithmic bias. I'm sure many of you on this webinar will have already come across the term, but if you haven't, don't be too kind of put off by the jargon. Essentially, it means that when artificial intelligence is being used to make decisions, there are ways in which unfairness and indeed unlawful discrimination can creep into the decision-making process. And I want to acknowledge that, in one sense, it's rare, if ever, that is the intended effect. The problem is much more likely that this is the unintended consequence. And we describe this as being a bit like awakening a zombie, because the way in which AI is used to make decisions often relies on something called machine learning. In other words, if you take the following hypothetical situation, imagine that a bank is using AI or an algorithm to make home loan decisions. In order to make that system work, it has to train its system on as many previous decisions as it can find. And so what we are seeing is that it would be really common for it to go back 20, 30, 40, 50 years even in the bank's records to, I guess, train its system to be able to make decisions. Now, the problem with that, and this is why it can be like awakening a zombie, is that in this case, home loan decisions from 30, 40, 50 years ago were much more likely to disadvantage women and other groups. And so the risk in using that process without proper controls and protections in place is that the progress we have made, in this case towards gender equality, not getting there yet, but certainly making progress as compared with 30, 40, 50 years ago, could be undermined by the use of the algorithm. In other words, the algorithm could learn from those very old decisions that women are less deserving of home loans, or indeed less likely to be able to pay back home loans. Now, we know that that's not the case. We know that that is wrong, but that sort of machine learning system, if it's not done carefully with proper protections in place, can have that effect. And so we've described this problem of algorithmic bias as being as causing three particular harms. The first is that it can literally be unlawful. It can cause unlawful discrimination. In the sort of example I gave before, if a woman is denied a bank loan because she's a woman, it should be no different if it's an algorithm that creates that effect than if it were a human who simply said, look, no, I'm not going to take you as a female customer. But even if that legal threshold isn't met, it can still, this problem of algorithmic bias can still lead to unfairness, which doesn't just create a regulatory risk, can cause reputational damage to the company or indeed the government agency. And then thirdly, again, returning to that hypothetical that I gave, if a woman is denied a bank loan because she's a woman, that I care about that because that's a clear human rights violation. And that alone should be enough to cause us to do something about it. But it's also a bad decision. The bank has lost a good customer that they would otherwise have been able to have a perfectly normal commercial relationship with. And so that's another very important reason why companies as well as government agencies need to take this sort of question really seriously. So as I said before, those three things that people care about are accountability, accuracy, and fairness. And with this issue of algorithmic bias, I think we can see how those three issues can, in a sense, come together or coalesce, and that the need for change is really, really clear. So in our report itself, we set out a series of recommendations to improve the way in which governments and the private sector should use AI, if they choose to use AI, to significantly reduce those risks of unfairness and unaccountable decision making. The next issue I want to deal with is a really important example of how we need to take a risk-based approach to the use of AI. There are some areas of AI where we heard very clearly from experts and the community at large that there are particularly great or high risks of harm. And one of the areas that we've focused on, and there's a chapter in our report about this, is the use of facial recognition and other biometric technology. So without going into all of the intricate technical details, facial recognition technology is something that is really made possible by the use of AI. And there are some areas of facial recognition that are relatively low risk. I emphasize the word relatively. It's not no risk, but relatively low risk. So people with certain types of smartphone, for example, will be familiar with the ability to hold up your smartphone and use facial recognition, basically instead of a PIN or a password. And that's what's known as facial verification or one-to-one facial recognition. And that is lower risk than some of the areas that we are most concerned about. By contrast, one-to-many facial recognition is something which involves the use of this technology to identify people in a crowd. Perhaps the best known example of this being used at scale is in a number of different parts of China, where there's what's become known as a social credit scheme, or a series of social credit schemes that are used in different parts of China, where someone might be identified using facial recognition when they're, for example, jaywalking, crossing the road without following the road rules, and a camera that has facial recognition empowered in it is able to identify that individual, and they lose social credit points, which in turn restricts their ability to live a normal life, basically. So that in a liberal democracy like Australia seems quite deeply concerning, and perhaps we're some distance from getting it. I certainly hope so. But we are also seeing the increasingly enthusiastic use of facial recognition by police forces, including here in Australia. And perhaps the biggest trial of the use of facial recognition to identify people in a crowd was by the London Metropolitan Police. So the outcomes of the first trial that they did a couple of years ago came out using Freedom of Information law. And it was quite striking. So they were able to identify 104 people using that technology. The problem, as this screen shows, is that 102 of those matches were wrong. It was about a 98% false positive rate. A truly horrifying thought when you think that when someone makes an error, when a police officer makes an error in identification, the possible human rights consequences are profound. The police may take all kinds of coercive action against the individual. They may be falsely arrested, unlawfully detained, and a range of other things that can happen. And when we acknowledge the very important work of people like Joy Buolamwini in the United States and Kate Crawford herself, which shows that facial recognition is more inaccurate in respect of people with darker skin, in respect of women, in respect of people with disability, we can see how injustice could become clustered around particular groups, which would be deeply, deeply worrying. But as our report also makes clear, even if the technology were perfectly accurate, and it is not, it is, just to be clear, it is probably less accurate than anyone you know who is not blind. So it is very prone to error. But even if it were accurate at a much higher rate, we would still be concerned, because this sort of technology, if we're not mindful about how we use it, could cause us to creep towards a situation of mass surveillance. And so just to wrap up what I'm saying about that, what we've said in the report is we need to take a risk-based approach that is very clear-eyed on some of the uses of AI that have particularly high risks. And there needs to be a clear set of legal rules that protect us against harm. And so when we talk about facial recognition, we say those high-risk uses should be prohibited, as has occurred in a number of jurisdictions around the world, including San Francisco, which in some ways is, you know, the home of artificial intelligence. So high-risk uses of AI should be subject to a moratorium. Should press stop and make sure that only with proper protections in place can that sort of technology be used. So to wrap up, before I move into questions, if you're interested in going a bit deeper on some of the issues that we've set out, our final report is available at tech.humanrights.gov.au. The report itself is a couple of hundred pages and is, I guess, the perfect read for any civil society advocate around. But we've also acknowledged that sometimes a report of that length can be a bit hard to go into, or people don't always have the time to do that. So that website that we've set up also provides other ways in which you can engage with the material. There are a number of summaries of key issues. There are some videos and other accessible materials as well that people may be interested in. And the final thing I'll say before I move to questions is just a plug for some of the other webinars we've got coming up. So on the 22nd of June, we have a webinar just like this one, which is focused specifically on accessible technology for people with disability. We have an entire part of our report dealing with that. And then the following day, on the 23rd of June, we have a webinar dealing with government use of artificial intelligence. And both of those webinars are, like this one, free of charge, and you can register at our website, tech.humanrights.gov.au. So I'm now going to switch gears a little bit and invite my two fellow panel members, Kate Crawford and Hugh de Kretser, to answer a few questions. So I'll remind you that you can ask questions using the Q&A function, and we're going to get to those questions very soon. But I might start by taking the chair's prerogative and ask a question of Professor Kate Crawford first. So Kate, you've advocated very powerfully for more rigorous testing of artificial intelligence before it is used on real people. And so in particular, you've been a pioneer of algorithmic impact assessments. We've picked up the same idea, basically, using different terminology. We call it human rights impact assessments. So can you tell us a little bit more about what happens now in terms of the use of AI and what needs to change? What would more rigorous testing look like?
Well, first of all, may I start with a congratulations to you, Ed, and to everyone at the Australian Human Rights Commission for this extraordinary report. I know how much work goes into these things, and it really does reflect so much of the state-of-the-art conversation. So thank you for doing that work. You know, when we think about what's happening now, it's really quite extraordinary that most AI systems are developed and deployed with very little consideration of their impacts, either in the short or long term. And they don't go through rigorous testing before they're simply deployed on millions, sometimes billions of people. And unfortunately, the downsides are often experienced the most by marginalized populations. And we've had so many examples just in the last couple of years. I mean, of course, we've seen Apple's own creditworthiness algorithm downgrade every woman who applied. We've had Amazon's resume scanning system also downvote all female applicants. We've had racial disparities in all facial recognition systems that are commercially available, as well as in Compass's own risk assessment tool inside the criminal justice system. And then, of course, there's age bias in Facebook's own algorithms and ad tools. The list goes on forever. So the question is, what do we do about it? And I'm really, deeply grateful to the work of scholars like Ruha Benjamin. You mentioned Joy Buolamwini, and of course Timnit Gebru's breakthrough work here, and Sophia Noble. We've seen how many times bias gets into these systems, but there are so many more examples that we don't know about. So we need some sort of systematic approach to test these systems, but also to involve more people in this conversation. It shouldn't just be Silicon Valley deciding what's good for the entire world. We need to have our own communities being part of these conversations. So, working with scholars like Jason Schultz and others, there are these ideas around algorithmic impact assessments. And the reason why this is, I think, a really good recommendation that I see in your report as a human rights impact assessment is it allows us to do internal assessments of how a tool works. We actually see, what is the algorithm doing? What's the data that it's been trained on? But we also get to come up with an action plan as to how to address those risks and then present this to the public for comment. This is such an important step that gets left out, which is how can people actually say, hey, we may not want to have facial recognition in our community or in our housing block, which is a big fight that just recently happened in New York City. What are the ways in which the public can have a say? That's something that I think is incredibly important here. How do we actually include affected communities in this process?
That's fantastic, Kate. Thank you. I'm going to pose a question essentially to each of you, Kate and Hugh, now, because it's clearly one that is coming through very strongly via the Q&A. And essentially, the overarching question is this: what do we need to learn from our experience of Robodebt, and particularly regarding the development and use of artificial intelligence? And again, I might start with you, Kate, because in Atlas of AI, you talk about something that's very important, but I think very little known in the wider community. You've got a great term for it. I think it's photomation, which is something that is crucial for AI and machine learning. One of the questioners, Kate Greenwood, pointed out that Robodebt was built on faulty manual processes. It amplified the fairness, so unfairness, I should say. So I wonder whether you can comment on that overarching question, but particularly drawing on that concept of, I guess, how humans and machines can come together to do terrible things as well as really great things.
Happy to. I mean, one of the things that's really common in conversations about AI or even just algorithmic systems is this idea that somehow they're autonomous, they're intelligent, they're doing their own thing in the cloud. And nothing could be further from the truth. All of these systems have been created by people, the data has been labeled by people, and there are many ways in which errors and bias can creep in. The term photomation, I can take no credit for, that's a term by the brilliant Astra Taylor, really thinking about the sort of the fake forms of automation that in and behind so many systems that we use today. The scholar Mary Gray also uses the term ghost work, that there are these forms of work that are used to prop up algorithmic systems to make them appear intelligent. And there's lots of things to be learned about how that type of work is. Traditionally, it's very exploitative, it's very underpaid. People are paid a few cents per task, and are often given really, in some cases, impossible tasks, like here are 50 images and you have to sort them into categories in 1 minute and decide, is this a picture of a person who looks like a person in debt, or does this look like a person who is a kleptomaniac? These are actual examples from well-known AI training sets that I've studied in the past. So certainly Robodebt, I think, reminds us of two things. First of all, these systems are never perfect. They're never autonomous. They are always the products of human systems and human histories. So they can have forms of structural bias built into them, and in some cases, just absolute egregious forms of error. And the other thing is that there are always things that can be done. in the beginning by testing how these systems work and by thinking about their implementation. It's much harder after the fact to actually dismantle these infrastructures or to trace how much harm they've caused. But I'd also love to hear from Hugh about sort of his views specifically on how Robodebt played out.
Absolutely. Over to you, Hugh.
Yeah, so I this morning I was reading Justice Murphy's judgment on Robodebt, and where he describes it as a shameful chapter, a massive failure of public administration. And it's such an important question to go, how did we get here where 433,000 people had alleged debts of $1.7 billion in letters that was, I think there was something like a million letters that were sent to people alleging these debts based on a completely flawed application of technology. How did we get here? And what can we do about it to prevent this from happening in the future? And when I looked at Robodebt and previous work that we've done around, particularly around metadata and facial recognition technology, what you see time and time again is governments being seduced by the promise of technology in helping them to run government more effectively, save money, deliver public services. So typically there's no sinister reason behind this technology. There's just a seduction and a complete lack of application of a risk assessment and understanding how this is going to affect people in people's everyday lives. And I come back to the recommendation in your report, Ed, and congratulations on the report. I think it's an excellent report, and this idea around AI impact assessments or human rights impact assessments to go, what's actually going to be the impact of people on of these types of automated programs? And it is so bleedingly obvious to anyone who has received Centrelink and is declaring income that if you are using this system of averaging out ATO income and then automatically generating alleged debts because of it, applied to a system where there are millions of abandoned calls because people can't get through to Centrelink to actually speak to someone about it, where there is just a massive, I mean, the judge described it as an asymmetry of resources and information and power. So very vulnerable groups of people who are affected by these debts. There was evidence in the court of people contemplating suicide because of receiving these debts and the inability to address them, and evidence of one man who committed suicide after receiving these debts. You just go, you have to think so carefully and test and involve the people who, the communities who this technology is going to be applied against, to make sure that you can anticipate the implications of how it's actually going to play out. And obviously, from a human rights law point of view, you need to make sure there are the proper legal safeguards in place. And time again, what we see with whether it's metadata or facial recognition technology or this proposed national database that governments around the country will be able to access for identity matching purposes, you see insufficient thought and insufficient safeguards applied to these seductive technologies.
Thanks, Hugh. I want to pick up on a couple of the themes that you've adverted to there. You talk quite rightly a lot about testing. The former UK judge Kay Firth Butterfield, who now leads the World Economic Forum's work on artificial intelligence, she made a really interesting observation. She said, too often we beta test new technology on literally the most vulnerable people in our community. And that certainly is a criticism that has been applied to the Robodebt scenario. Do you have an observation about that? And in particular, do you have any advice for civil society organisations to respond to that phenomenon and uphold the human rights of particularly people who are not necessarily well placed to look after their own interests?
Yeah, I think it's we do a lot of work at the Human Rights Law Centre around social security and your right to a decent standard of living, and when governments need to support people who are doing it tough. And there is a really concerning trend of particularly federal government attempting to control people's lives, whether it's through the cashless debit card, impose more onerous compliance obligations, through the remote community development program, the Parents Next program. There's lots of examples of this being done from a policy or ideological point of view, where governments are trying to ration their resources, and based on this belief that there are people that are unfairly receiving some kind of benefits. And then you apply the promise of technology to that, and suddenly you have this huge risk of that ideology being matched with flawed technology applied at scale to people with very imperfect ways of actually challenging or knowing and countering that use of technology. And so, yeah, these types of technologies have particular importance for vulnerable communities, which means it's particularly important for civil society to understand the technologies, understand how they're going to be used, for governments to speak to those communities, to understand them. We were talking earlier about the impact of independent assessments in the National Disability Insurance Scheme, and the risk of automation and AI being used to assist that flawed independent assessment process. And so civil society has to engage with these topics. And unfortunately in Australia, I think we're way behind, and there is a lack of, it's why your project at the Commission was so important. But when I look around civil society and the human rights and legal space in Australia, we are way behind equivalent countries overseas, particularly the US, obviously, where there's just a much greater scale around this. It tends to be academics like Kate. It tends to be smaller volunteer specialist privacy or tech organisations. Some of them are getting some funds like Digital Rights Watch, which is good to see. Or then it tends to be mainstream human rights organisations like the Human Rights Law Centre or Amnesty or the ACLU in America, where you're trying to build that capability into a legal and advocacy organisation to understand how facial recognition technology or metadata or AI works. But it's critically important. And we've done a 10-year strategic plan in our organisation and said, what are the key trends that are going to be impacting on human rights that we're not working enough on now that we need to grow? And technology and human rights is one of those top 3 trends. So we're actively looking at how we can increase our work in this area. So far, it's been done through the democratic freedoms lens, looking at the impact of metadata on journalists and public interest journalism, on protest, and the threats of facial recognition technology to protest in the criminal justice space. But when you look at across the board in human rights, as you point out in your report, you start off looking at privacy, and then you realize that technology is going to affect almost every sphere of human rights work in the future. So it's absolutely imperative that civil society understands and does more in this area.
Thanks, Hugh. Kate, I want to come back to you now on another theme that has featured very strongly in the questions from the people listening into the webinar. And that is really related to the responsibilities of the private sector in respect of the use of artificial intelligence. What we've said in the report is essentially can be boiled down to 3 key principles, and this then is reflected in our recommendations. The first is that the private sector have to follow the law. And that may sound sort of so obvious that it doesn't need to be said, but there's certainly a kind of almost a fetish for the idea that you just move fast and break things. The rules, and including the laws, are there to be kind of set aside, and that's what innovation is built on. We say that that's just a misreading of history, and is actually really dangerous when you're using AI in areas where people's rights can actually be affected. It may be different if you're doing something very low stakes, like developing a new computer game, but in a high stakes area, that's unacceptable. The second thing we say is that there needs to be some small but important adjustments to the law reform to really ensure that those principles that we started with, that accountability in particular, and fairness and accuracy are maintained, and that the worst risks are addressed. And so that reform should apply to the private sector, acknowledging that the private sector is regulated less closely than government, but still the private sector makes crucially important decisions. And then the third thing is essentially about encouraging good behaviour by the private sector. So what are the things that we can do? We've set out a number of those things that essentially encourage the private sector companies to innovate consistently with our values as a liberal democracy. So that's a very long-winded kind of run up there, Kate. But I guess I was keen for you to reflect a bit on what the responsibilities are for the private sector, and feel free to jump in on any of those principles that I've laid out, or we'll go in a different direction.
I mean, they're excellent principles to begin. Certainly, I think if we look at the last 10 years, one of the most striking features is just how little regulation the tech sector has had to contend with, and just how much damage that has caused. So as much as I think, yes, certainly following the laws, tax laws to begin would be a really nice start, I actually think we need to do a lot more in terms of law reform. Certainly one of the things that I've advocated for in the past in research over multiple years is to waive trade secrecy that's used to guard the way that AI and algorithmic systems are designed and deployed. It's extremely difficult to audit and investigate these systems if we cannot actually look at how they work. And certainly there are laws in the US, like the Computer Fraud and Abuse Act, that I think has been overly broad and has prevented researchers from understanding how these systems work. Certainly companies could choose to waive trade secrecy, say in a government system, and say, we will allow people to come and understand how this system works and how it fails. As a bare minimum, we need that. But certainly, I think we're at a moment in history where we need to think about omnibus regulation for AI systems. And now, of course, the EU just 6 weeks ago released its first draft outline for regulations for AI. I think there are some excellent points in there. I think there's more to be done. It certainly puts a lot of emphasis on notice, just letting people know that a facial recognition system is working or an emotion detection system is working. Whereas I'd like to see more ways in which people can say, we don't want to be parts of these systems. We can actually opt out entirely. Trying to think about sort of stronger guardrails, I think, is a really important question. But it's interesting. I mean, in some ways, I think Australia is the perfect place to do this. I mean, we've got a really good history of walking a line between, embracing a new technology and thinking about safety recommendations around it. I mean, here I'm thinking of the seatbelt. So of course, cars were around for 60 years before seatbelts were mandated. And we had obviously, mass death on account of this new technology. And in fact, the very first regulation for seatbelts was here in Australia. In fact, it was in Victoria. So we've got this really good example of how Australia can be innovative in terms of how we think about regulation and policy. So certainly my hope is that when we think about what the private sector can do, as much as we would like to encourage good intentions, that we actually have accountability mechanisms that enforce good behavior, particularly when so much is at stake. We're talking about people's ability to get jobs, to get healthcare, to go to the school they want to go to have a, due process in the criminal justice system. If we're going to allow algorithmic systems to be actors in those systems, then they must actually have strong regulatory frameworks as well.
Thanks, Kate. Did you want to comment on that as well, Hugh, the role of the private sector?
Only briefly to agree that what we've seen is that where you have a free-for-all, that you get bad applications of technology, and so there's a need for regulation, and this sort of there's been an unhealthy, I think, trend of governments vacating the field in terms of tech regulation, which has been unhelpful. It's given us the evidence that that doesn't work. We've seen it with Facebook, for example, in the Cambridge Analytica scandal. Clearview AI, there's been some good investigations of that. And now we're seeing that police forces in Australia, at least maybe through individual officers, are using some suspect technology there. I was on the Victorian Law Reform Commission when we did a review into public surveillance in public places back in sort of around 2010, so 11 years ago. And we made a recommendation around the need to improve privacy protections for people, not just from government surveillance, but from private surveillance as well. Those recommendations have not been implemented. The Australian Law Reform Commission made similar recommendations, I think in around 2013, 2014. You pick up on this in your report and say that our law is failing to keep pace with technological change. The power of any device in terms of a tracking tool or in terms of the volume of data that it can send anywhere in the world is proliferating, and it's absolutely important that the governments keep pace with that change, which is why your report's important, but also the need to not just look at obviously the public sector, but the private sector as well, and noting also that often it's governments outsourcing obligations or public services to the private sector. And in Robodebt, it was private debt collectors who were chasing up the debts, often using, like, it's well publicized the impact on individual people of being harassed by private debt collection companies. Yet here was the government with unlawful debts outsourcing the debt collection aspects of that to private companies. So there's that trend as well.
I always try to kind of offer some hope as well as kind of presenting an accurate but sometimes bleak picture. So I'm going to try and move to a more positive kind of frame here. What gives each of you hope, Kate and Hugh? In particular, are there places where this is being done really well, where in other words, the best of artificial intelligence is being able to be harnessed, and the risks are being addressed reasonably well? Or can you give examples of things that give you hope? Kate, do you want to kick off?
Well, certainly. I mean, I think they're having just sort of spent the last 5 years writing Atlas of AI and looking at the full costs of building AI systems from nose to tail, from their environmental implications to labor to data protections. There's a lot to be concerned about. But in doing that work, I think the thing that I was most optimistic about was twofold. First is that there's actually quite a lot of low-hanging fruit in terms of how we can actually start to regulate these systems. I mean, we wrote the Algorithmic Impact Assessment report, gosh, I think over 4 years ago now, and to see that that's been picked up by world governments, it has been fantastic. It's something that governments can do now to actually make systems more fair, to audit, which you call for very strongly in your report, Ed, to audit what they use and to ensure that before purchasing new systems, these kinds of rigorous assessments are applied. That's starting to happen. So I'm deeply optimistic to see that. I'm also really optimistic to see the different coalitions that are forming, from NGOs to activists to people who are just concerned to make sure that these systems are affecting the communities in ways that are fair and just. So we're actually starting to see communities who previously didn't necessarily work that much together actually come together around these issues around AI and justice. And that's really, to me, inspiring. And I hopefully think it means that we can decenter this idea of tech utopianism, or the idea that AI is a tool that can simply be applied to every institution across the board without thinking about its impacts. That is starting to change. So I think there's an attitudinal shift right now that is causing, I think, certainly a greater sense of realism and perhaps some skepticism about sort of the over promises coming from the tech sector, and really finding new ways to make decisions about how we want to live and what's a fair way to include technologies, rather than allowing the tech sector to tell us how they'll be applied.
Hugh, hope?
I think Let's just talk about the incredible advances in technology. The fact we're on a webinar right now. I'm here in Melbourne, in Boon Wurrung land. Ed, you're in Sydney and Gadigal land. Kate, you're in New York, I think. Anyway, East Coast, US. So technology has enormous benefits that are changing our lives for the better in many aspects, bringing us together. From a human rights point of view, Ed, you'll be talking about the promise of technology around improving the lives of people with disability as just one example, in medical science in so many different ways. So it's about extracting the good while protecting against the bad, and the good gives me hope. When I was over, I think capability in civil society is improving around knowledge and the partnerships that you talk about, Kate, and but there needs to be much more of that. We need tech experts in human rights organisations. We need those partnerships to build the capability on both sides, or in multidisciplinary ways. One area of hope from government was the COVID Safe app, and it's probably deeply ironic that I'm mentioning that, because the app was roundly criticised for not working. But I was overseas in the US at the time on long service leave, watching the policy debate play out around this app. And the government was so desperate for the app to work from a public health perspective and a public trust perspective, that they actually listened to privacy experts and tech experts for the first time that I have seen in my career, and actually developed a process of building in proper safeguards and saying, while we might have all this useful data for all these other purposes that might be helpful for government, this is an app which is a purpose of public health, and we're only going to use it for that, from that point of view, which contrasted to their My Health records, where they said, ignored normal privacy principles, said it's an opt-out system. We're going to grant law enforcement access to your private health records unless, and all the wrong things to destroy public confidence in this COVID Safe app. It doesn't work very well, but at least they got it right. But there was an accident of history, because there was a particular policy imperative that meant that they respected privacy. That needs to happen every single time. And to do that, we need the kind of things that you've recommended in your report. We need a stronger human rights protections. We need a Charter of Rights here in Australia that protects the right to privacy. We've seen our sister organisation say in the UK, Liberty UK, use the right to privacy under the European Convention and the UK Human Rights Act to try and address police use of public facial recognition technology to address mass surveillance exposed by Edward Snowden. We do not have those same legal protections here in Australia, and that needs to change.
And you touched on a really important issue there, Hugh, which I did want to come back to. I know we're running out of time, which is what civil society organisations can do. So I think what I'm hearing you say is being involved in these debates is really important. Having people with skills and an understanding of AI, and particularly the weak points in AI, working within civil society organisations. Kate or Hugh, is there anything else that you particularly wanted to emphasise that civil society can do in this space?
No, I'd just add that I think civil society has an enormous amount of power in this space that is perhaps unrecognized. And there's a tendency, I think, for civil society organizations to feel sidelined, to feel as if they don't have the right tech expertise or the right standing. And I would say it's really important that this sector feels empowered to play a very big role, particularly in terms of not just pushing back on systems that are clearly going to produce forms of harm to marginalized communities, but also to really make this a public debate. You know, one of the things that, again, speaking about optimistic notes, just looking at the questions today, we're at a level where people are asking really sophisticated questions about system design, implementation, long-term effects. That's really thanks to what's been happening in the civil society sector and in journalism, with the people who have been consistent voices sharing investigations around how systems work. So, thinking about the way in which we can continue to center that work, to ask hard questions, and to produce stronger accountability mechanisms. That's kind of the core work of the civil society sector. And Australia has a really strong chance at actually baking in protections now before we start rolling these systems too deeply into our institutions.
And I was just going to, firstly, a shout out to Victoria Legal Aid and their team for understanding the impact of robo-debt and devoting resources to address it. I think there was something like 29 Administrative Appeals Tribunal reviews of robo-debt decisions, and ultimately the test case in the federal court that Victoria Legal Aid ran. So those resources for access to justice and empowering people to challenge decisions, which are often opaque, very hard to unwind. That was absolutely critical to addressing robo-debt, and obviously the class action went on from that, run by a private law firm. Collaboration is hugely important. Learning from partners overseas. We're a member of the International Network of Civil Liberties Organisations. Public surveillance is one of the key areas we're looking at, and so we're partnering with that project is led by the Irish Council of Civil Liberties. So there is more collaboration happening across civil society, which is good to see. But yeah, just endorse the things that Kate have said, and we need much more of this. We need philanthropy in Australia investing in this. I think Perpetual has done some great work bringing experts from Stanford over to Australia and trying to build civil society's capability and understanding how it affects the kinds of work we do and the services we deliver. We need more of the injection of philanthropy into those policy debates, the advocacy, and into the strategic litigation as well.
Thank you both. We're careening towards the end of our hour, so I'm going to quickly try and answer two more questions that came up in the Q&A that were directed towards us. The first was a really important and difficult question, which is the debate that we're having about technology, is it really about problems with the technology, or is it really about problems with our systems of accountability and fairness and human rights? And the short answer is, from our perspective, is that it's both. I alluded to this before, but to take that example that I started with, the woman who applies for a bank loan and is treated unfairly, it should make no difference if a woman applies for a bank loan and is greeted by a sign that says we just don't have female customers. Everyone in Australia would know that that is clearly unlawful, that's clearly discriminatory. It is no less unlawful, it is no less discriminatory if it's an algorithm that has the same effect. And our law, and particularly our regulatory ecosystem, needs to get better at enforcing and ensuring people's rights, enforcing the law and ensuring people's rights are protected when it comes to the use of technology. So that's the first point. The second question was, what comes next with our report now having been tabled? So one of the, I guess, features of the Human Rights Commission is that our reports are not self-executing. We set out a vision of how the world should be, and then we work really hard with government to move towards implementation. It's also true that in the several decades since the Commission was established, the reforms that have been most successful have been ones that where the community has come with us. We went to enormous trouble to listen to the community for this project, and I think our recommendations are the stronger for it. But if there are people in civil society in particular who feel that there are important recommendations that need to be taken forward, then those are things that obviously you can raise directly with the government as well. So now it just falls to me to thank again Professor Kate Crawford and Hugh de Kretser very much for your insights and wisdom today. Thank you also to the audience for participating and providing such thoughtful and important questions. We'll make this webinar available on our YouTube channel, and you can register for future webinars at tech.humanrights.gov.au. Shortly, you'll be sent a survey which you can fill out in due course as well. Thank you very much from everyone here at the Australian Human Rights Commission.
Thanks, Ed. Thanks, Kate. Thanks to the interpreters.
Thanks, Ed. Thanks you. Thanks, everyone.